In this session, we are going to discuss about immunities. Immunities available to a registered trade union, that is discussed in Section 17 and Section 18 of Trade Unions Act 1926. A registered trade union is a distinct legal person. When a trade union is registered, it will acquire a separate personality and will achieve an independent legal status. In fact, certain advantages and rights emanate from the registration of a trade union under the provisions of the Trade Unions Act of 1926. When a trade union is registered, all communications and notices may be addressed to its registered office, and a registered trade union has the following immunities. The first one, immunities from civil liability, that is discussed in Section 18. So Section 18 discusses about immunities from civil liability. No suit is maintained in a civil court for the activities of the trade union or any act done in the furtherance of a trade dispute. Even if the act done by a registered trade union induces some other person to break a contract of employment or is interference with trade or business, no civil action would lie. The immunity is available against the union, its office bearers, and its members. The activities should have been done in contemplation or in furtherance of a trade dispute. Otherwise, a civil action would lie. According to Section 18, Subclause 2, the immunity is extended to tortious act also. So, immunity from civil liability is discussed in Section 18 and it is extended to tortious act by Section 18, Subclause 2. So, in a case that is Dalmia Cement Limited versus Naraindas Anandji Becha, that is 1939 case. The court held that the section does not afford immunity to a trade union or an office thereof or any act of deliberate trespass. So in this case, it was held that this immunity is not extended for deliberate trespass. Again, in court, in Sri Rama Vilas Service Limited versus Simpson, Sri Rama Vilas Service Limited and versus Simpson, and in Group Companies Union case, that is 1979, Simpson and Group Companies Union. Sri Rama Vilas Service Limited versus Simpson and Group Companies Union 1979. In this case, it was held that it is not within the purview of the court to prevent or interfere with legitimate right of the labor to pursue their agitation by means of strike, so long as it does not indulge in acts unlawful and tortious. In another case law, that is Ram Singh and others versus Ashoka Iron Foundry and others, that is 1993 case. In this case, it was held that a suit for perpetual injunction restraining the workman from indulging in unfair labor practice is deemed as one of a civil nature and hence cognizable under Section 9 of the Civil Procedure Code. So, in Ram Singh and others versus Ashoka Iron Foundry and others, 1993, in this case, it was held that a suit for perpetual injunction restraining the workman from indulging in unfair labor practice is deemed as one of civil nature and hence cognizable under Section 9 of CPC. Therefore, where the court has barred the workman from holding meeting, dharna, and interfering in the rights of a company, such a restraint does not curtail the trade union activities of the workers. It cannot be construed as an unjust, and the workmen are at liberty to carry on legitimate trade union activities peacefully. So that was held in Ram Singh and others versus Ashoka Iron Foundry and others, a 1993 case. Now, another case that is P. Mukindan and others versus Mohan Kandi Pavitran, that is 1992. P. Mukindan and others versus Mohan Kandi Pavitran, 1992 case. Here, it was held that a strike per se would not be an actionable wrong. So, per se, a strike is not an actionable wrong. Further, the office bearers and the members of a registered trade union are immune from legal proceeding linked to the strike of the workman under provisions of Section 18 of Trade Union Act. So, the immunity from civil liability is discussed under Section 18 and it is extended to the tortious act in Section 18 Subclause 2. And the next immunity is immunity from criminal liability, and that is discussed in section 17. So immunity is discussed in section 17 and 18. 17 deals with criminal liability and 18 deals with civil liability. 18 subclause 2 extends the immunity of civil liability to tortious act. Now, immunity from criminal liability, section 17. Section 17 of the Act confers immunity from liability in case of criminal conspiracy, that is 120B of IPC. Immunity from liability in case of criminal conspiracy committed by an office bearer or member or office bearers of a registered trade union, in the sense that immunity is available only in respect of agreement between the members for the purpose of furthering any legitimate object of the trade union. If the agreement is to commit an offence, no immunity can be claimed. Registered trade union have rights to do certain acts in furtherance of their trade dispute, such as to declare strike and for that purpose to conspire with their members to abstain from their work. Now we have a case law, that is Roshtas Industries Staff Union versus State of Bihar. Roshtas Industries Staff Union versus State of Bihar. In this case, the question of law was whether the employee have any right to claim damages against the employees. So here the question was whether the employers have any right to claim damages against the employees participating in an illegal strike and thereby causing loss of production and business. The court ruled that strike was illegal and there is a breach of statutory obligation. The court ruled that the employers have no right of civil action for damage against the employees participating in an illegal strike. The reason stated by the court was that when the employer declares an illegal lockout, the employers have no right of civil action. So it was in Roshtas Industry Staff Union versus State of Bihar. The court answered the question whether the employers have a civil remedy or civil action against illegal strike by the employees. So here the court held that where it is an illegal strike and there is loss, the employers cannot claim a civil action, same way as there is no civil action for the employees against an illegal lockout. So that was held in Roshtas Industry Staff Union versus State of Bihar 1963. Another case law, that is R.S. Rulekar versus Emperor, that is 1935 case, R.S. Rulekar versus Emperor. The court observed that an agreement to commit an offence would, under section 17, make the members of the union liable for criminal conspiracy. So criminal conspiracy is discussed under section 120B of IPC. Now another case law, that is West India Steel Company versus Aziz, that is a 1990 case. West India Steel Company versus Aziz, 1990. A trade union leader obstructed work in the factory for 5 hours, protesting against the deputation of the workman to work in another section. It was held that a worker inside the factory is bound to obey the reasonable instruction given by his superiors and carry out the duties assigned to him. The mere fact that such worker is trade union leader does not confer on him any immunity in that regard. A trade union leader has no right in law to share managerial powers, and he cannot dictate on to any worker individually or to workmen generally about the manner in which they have to do their work or discharge their duties. A trade union can espouse the cause of workers and can resort to lawful agitation for conducting their rights, but officials of trade union are not entitled to order a workman to stop his work or otherwise obstruct the work of the establishment. Where the officials of the trade union obstruct the work, the management is justified in proceeding against such worker and deal with him effectively. So that was held in the West India Steel Company versus Aziz. That is, a trade union can espouse the cause of workers and can resort to lawful agitation for conducting their rights, but officials of trade unions are not entitled to order a workman to stop his work or otherwise obstruct the work of the establishment. And if such a thing happens, there can be a proceeding against such worker and deal with him effectively. So that was held in the West India Steel Company versus Aziz. So with respect to immunities, that is discussed in section 17 and section 18 of the Trade Unions Act 1926. Section 17 deals with the criminal liability, especially with that of section 120B of IPC, that is criminal conspiracy. And it is all clearly stated that if the conspiracy is for an unlawful purpose, or unlawful object, there is no immunity. It is only for the lawful purpose and for the object of the trade, lawful object of the in furtherance of the trade dispute, or for the object of the trade union. That should be lawful. Only in that case there is immunity from criminal liability, else there will be no criminal liability. And in West India Steel Company versus Aziz, it is said that the trade union can resort to lawful agitation and initiate proceeding, but they cannot stop the workman from his work or stop the operation of establishment. In such a case, the establishment can take action against the particular worker. That was said in the West India Steel Company. And the civil liability is discussed under section 18, and section 18 subclause 2 extends the immunity from civil liability also for the tortious act. So that is with this section. Thank you for listening. Like, comment and subscribe. Please click that bell icon so that you get an update when I upload my next video or a podcast. Thank you.